Mr. Gazzola, I see you there. Ms. Baldwin. I do have us on for default. I do have a response to motion for default. What do the parties want me to know?
Well, as I said, Your Honor, I followed up and did not have this on my calendar, and so I'm not really prepared today. I'm supposed to be in another meeting right now. I obviously need, in light of the response that Ms. Baldwin filed, I need to check something with my process server, and I've not been able to connect with him. And so that's why I was asking. I contacted her office today in the hopes that we could kick this over for a couple of weeks so I could do that, and then I would respond to Ms. Baldwin.
Ms. Baldwin, go ahead.
The issue's really straightforward on a legal basis and very, very clear. So I would just ask for a 1 week set.
Mr. Gazzola, could you do this next week? It'll be at 1 o'clock, same time, Tuesday at 1 o'clock.
And with the warning, sir, that if you cross into November, the court is requiring our personal appearances beginning in November. So there is the risk for you there.
I'm fine next Tuesday at 1.
Tuesday at 1. Okay, I will get this. You'll be in front of Judge Basher, who regularly handles this docket. I will forward over the bench copies and any proposed orders.
Thank you, Your Honor. Thank you, Ms. Baldwin.
Very good.
Christian Bratton.
I didn't anticipate his presence. He hasn't participated in the entirety of this action. We had filed a motion for default, had filed that ex parte. Judge Basher had denied that, given the party's attempts at reconciliation earlier this year. He required Mr. Bratton receive service of that. He has been properly served, has not filed any sort of response, at least in my review of Odyssey this morning, isn't present for purposes of today's hearing. So I am asking the court to enter that order on default, and I did include final order also for signature today.
Okay. I do have in here, and I checked the file there. I do have the proof of service, and I don't have any response from him. I first have the order on motion for default that I will sign. I have the findings and conclusions about a marriage. Having signed the order for default, I will sign the petitioner's findings and conclusions. I will sign the petitioner's legal separation decree. Then we have the child support worksheets. Child support order. And I think that's all I have.
That should be
sound right?
Yep, that should be it.
I will hand this up to the clerk. Anything else on this matter?
Nothing else from me.
All right.
Thank you.
Thank you. The Poland matter.
Good afternoon, Your Honor.
Yeah, good afternoon, Ms. Jocelyn.
Good afternoon.
We did not receive any actual written objections, just an email that says I object. So I don't actually know
Okay.
what the objections are.
So Mr. Poland typically, and I know you're doing this unrepresented, but I know typically folks will either file their own order so that I can compare where there's disagreement, or they will go through and redline the proposed order with the places they disagree with.
Okay. Yes, Your Honor.
How much of the proposed parenting plan and temporary order are you in disagreement with?
I would have to review all of it again just to validate that. I know I stopped reading after one of the first. I'm gonna pull it up as we speak right now. So the main thing I wanted to object to would be it was about visitations and it involved my medication.
Okay.
That I objected to that part because that has been something that I have been consistently on since the time of our breakup and me moving out of that house. So I want to object to that one. And then other than that, from what I've seen so far, from what I remember, everything else is okay. That's just the only thing that is I will be objecting to, because it goes back to supervised visits based off medication purposes.
Okay, what page? Oh, hold
We
on.
can be heard to
Yep, of
page
course.
2.
Of
She's
course.
referring to.
Ms. Jocelyn, hold tight. So Mr. Pullen, so are you looking right now at the parenting plan that was proposed by Ms. Jocelyn?
Yes, ma'am.
Okay, and you're talking about if you obtain a prescription, you shall be evaluated for,
Yes,
et
ma'am.
cetera. Okay,
Yes, ma'am. That, and the reason why behind that is because before the breakup, the part of the evidence I submitted, those 3 white sheet of papers that had Becca's handwriting as well as she submitted, that was prior to our separation, and she was using that as a target to make sure I couldn't have my kid. And prior to me even getting on that, prior to our separation, me and my prescriber at Columbia Wellness had 2.5 months of talking about it prior to getting put on it because of my past before having Riley or even meeting Rebecca.
okay, go ahead, Ms. Jocelyn.
Yes, Your Honor. You indicated that we would be utilizing our parenting plan, and you specifically gave me the sections to change, which was 3A, 3B, 4, adding my client, reserving on substance abuse. So what Mr. Pullen is arguing now is something that he should have argued in court. I don't think he quite, and this is not a negative, this is a typical pro se thing. I don't think he quite understands that today is not a time to argue the orders. It's time to argue is what I put down what the commissioner ordered. And so the changes to section 4 is you said leave in anger management, domestic violence. If you look underneath that, it says substance abuse reserved. And then I added in a second section so it wouldn't be confused for my client with your order that she do a mental health eval and he be able to provide input. But you did not request any other changes at the hearing to the section 4.
Right, and so I'm just, and maybe I'm just going back to your original proposal. Hold tight.
No problem.
Yeah, that is, I was just wanting to verify that that is the same language in number 4, because my ruling was I was adopting Ms. Jocelyn's proposal with the changes that we went through at the hearing. The language regarding prescriptions was in her proposed order, so that her proposed order under 4 is in accord with my ruling. So I will go ahead and maintain that. Mr. Pullen, did you have any other points of disagreement with the order?
No, ma'am. Off the top of my head.
Okay. Ms. Jocelyn, anything else you wanted me to know?
No, Your Honor. So we would just ask it signed as is, as well as the temporary. I don't know if he has any objections because we didn't get any.
There's also the temporary family law order. This one requires utilization of our family wizard. We did not put your address in there because it did say pending GAL investigation. We can later determine allocation of GAL expenses. Do you have any disagreement with our family wizard for communication?
We've been using that and used that for the video call this past Monday. I plan to visit Riley this Saturday with my girlfriend and her daughter. Other than that, everything else is fine. Nothing else to complain. I did pay my portion, my 50% to the guardian ad litem, Miss Lawrence over there. I still owe $10 because I was $10 short during our meeting. And I appreciate the time that she met up with us. Other than that, that's about it.
Okay. Okay, I'm going to go ahead and sign Ms. Jocelyn's order as it does comply with my ruling at our hearing. And then I do believe we have a forward date for you all, if I'm not mistaken already.
We do, Your Honor. We do have a 30-day date and Miss Lawrence is on. I'm wondering if we can take that off since both parties have been in contact and she would know more about payments, but if that's all we were doing, I would ask we take that off.
Okay, let me, Ms. Lawrence, are you able to hear the court?
Yes, I am.
Okay. We did have that 30-day review. Do you think that we should keep that on? Do you need it? Have parties paid you?
Yeah, parties have complied. Everything is just fine and we're ready to rock and roll.
That's great news. Hey, well done to both parties then. So let's go ahead and strike October 29th at 1 o'clock. Our next pre-scheduled court date is January 28, 2025 at 1 o'clock. If parties need to note something on sooner, you obviously are free to do so.
And Your Honor, just so
Yeah.
I was thinking about this for clarity, for section 14 language number 1, the standard keep apprised. Do we
Okay.
want to write reserved on that based on Your Honor's ruling about revealing his address? I just don't want there to be conflicting orders now that I think about it.
On number 1, address and phone number.
Yeah.
Yeah.
At least the address. I apologize. I didn't want to change anything based on your orders, but I thought that might be a conflict based on Your Honor's
No,
ruling.
I think that makes sense. I'm glad she
Thank
caught
you.
that. I think I'm gonna strike out the requirement to provide your address. It'll just be you guys need to keep each other apprised of your phone numbers, okay?
Okay. So how would visitations go now, since I would be visiting down this Saturday, and then obviously we'll have to have a person to watch?
I'm not sure what you're asking me.
So because I'm on a certain prescription and I've been on the prescription since the beginning of a year, that would break the current order, which means I would have to go to supervised visits. So how would that work coming up this Saturday?
So
On that order, it says that if I obtain a benzodiazepine prescription, I will have to go back to supervised visits. With that being
Yeah.
this Saturday, how would that work when I am planning to be up there from 7 to 4? Do we have a supervisor to be ready this Saturday from 7 to 4?
that is not my ruling. Ms. Jocelyn, go ahead.
That's what I was going to say, Your Honor. That's not the ruling. That's not what the order says. It says if he obtains another one. And so as long as he's compliant with the rest, he gets his 7 to 4 visits. So it's not saying that because he's on, it's if he obtains another one, if he's on the same one. And I'm sure this is something Ms. Lawrence, who's very diligent, would also be able to figure out. So that's all reserved upon. So I'm not sure what he's talking about right now.
It was stated, and mainly it's, sir, that if you get on a new benzo and you refuse to participate in an evaluation or undergo treatment, that could impact unsupervised visitation.
Yeah, I just wanted to make sure I understood that correctly, because I took it as if I'm on it currently, even was a past one prior to all this, that I would go back to supervise. So I just want to clarify
Well,
that. As well.
And I understand that you still see an active provider, so I deem you in compliance. Okay?
Yes, ma'am. That's my only concern.
Okay. Thank you for clarifying. I appreciate that.
Thank you, Your Honor.
Thank you. And I made that one change per the address issue.
Thank you.
Thank you.
All right. Thank you. 08.
Thank you, Your Honor.
Thank you.
Your Honor, Josh Baldwin for Larry Ubel, who's also appearing via Zoom from my office.
Okay. Mr. Ubel, are you able to turn on your camera?
He may, Your Honor, he may have some difficulty getting it to work. Staff set it up for him. Oh, there he is.
There he is. Okay. And do you have Ida Ubel online? Someone with the name Ubel logged
Yeah, that
off.
was initially Ubi, then it was changed to Uber.
Oh,
I saw them change their name.
so probably
My
not even-
understanding was my client was not going to appear
Oh.
today. Maybe she surprised me and that was her, but I didn't know
Probably
she was going
wasn't.
to log on.
Okay. We missed one. All right. Okay. So there we go. I'm just going to mute him while we go through this. If there were any original orders, they did not make their way to me. Should I have that?
No, and
Okay.
typically what I'm doing now is depending on the response, it's easier just to set a presentation as opposed
Okay.
to the orders twice sometimes.
Perfect. Okay, so we're here for temporary orders, and I do know also restraining order. Is that still correct?
That's correct, Judge.
Okay. All right. Well, let me just get into that digital file here quickly. All right, so I do have the original motion and the stand-in temporary order and restraining order. Mr. Zandy, go ahead.
And thank you, Judge. The court is aware I do represent the petitioner and moving party of the motion before you today, namely Ida Ubel. My client has, I think, put forth a pretty straightforward motion in what she's asking for relief, and it's largely financial, as well as the restraining order. Yes, for a little bit of history, this is a case where these parties have been married for 54 years, separated a couple of years ago by design, not to save money, to save expense. I think both parties, at least my client nonetheless, was hoping that we could expedite this to a resolution and be done. She is of extremely limited financial resources. You saw that in the information provided. We did attend a mandatory settlement conference. Mr. Baldwin and myself have been in somewhat frequent contact trying to resolve this case. Unfortunately, it hasn't happened as of yet. In the meantime, my client continues to go backwards in finances to the point which kind of necessitated this motion, asking for the relief that's contained in my client's declaration and motion alike. Starting off, again, this is certainly, if we look at the standards set forth by RCW 2609090, certainly a maintenance case. Certainly the length of the marriage is on the very high end of long-term, sitting at 54 years. It's a case where my client is elderly, a case where she is unable to work, has no necessary or reasonable expectation to work. It's a case where Mr. Ubel, as well, is retired, but he enjoys the lion's share of the, I'm going to call it income or earnings. So that's what he has. He has 3 separate sources of income right now. Now, we detailed that for you. I think we're also largely agreed on the amount. Nonetheless, he's getting a Weyerhaeuser pension in the amount of $1,518 per month. He's getting an additional $3,824 per month from his VA benefit. And finally, $2,422 from Social Security. All in total, he's been getting a stream of monthly proceeds of $7,764 compared to my client's lone source of income, which is from her Social Security, which is $896. She's currently residing in the home. She's currently trying to piece together some kind of a pretty modest existence. Groceries, you look at gas, you look at some of the other obligations that are fundamental in every household. She's having a really hard time meeting those at this point. We do believe that given the length of the marriage, given the constructs of the RCW I've already cited related to maintenance, this is the case where the court typically looks to equalize the respective earnings of both parties. We're not asking for that. In fact, we're willing to give Mr. Ubel an approximate $900 per month benefit over that of my client, recognizing that she lives in the house with her adult daughter, recognizing that she just wants to be able to meet her budgetary need. We're asking for $2,500 per month in spousal support. I think that is certainly beyond reasonable given kind of where we are and how we've arrived at this situation, this point in time. We are asking for an effective start date on that order to be September 1. This is a case, again, where my client has gone significant period of time, hoping the case would resolve, bring this as a last resort. We filed this motion in early September, I believe it was the 11th or 12th. We do ask that this be set back retroactive to September 1st, given the time of the filing. As it relates to the restraining order, and again, I think this is one where I want to say Your Honor heard this a year or so ago under a separate cause number. You did issue the protection order that is still in effect, to the best of my knowledge. My client is asking for a secondary order through the divorce cause number to basically mirror what has already been ordered. She is asking that be extended over the unusual period of time that we typically see on a temporary basis. Just again, given how we've kind of arrived at this. This has been before you a couple of times. This is a case in which there was a criminal proceeding last spring in which Mr. was charged criminally for violating one of the protection orders. I believe that was the one. I'll let Mr. Baldwin address that, against the adult daughter who's residing with my client. Nonetheless, this has been turmoil since before these parties separated. And my client continues to tell you that she has a reasonable based fear of her husband. The fact that he has made threats, the fact that he has made some of those gestures which concern her and give her a cause for apprehension in his presence, I think is telling. We are asking for an order that he stay 500 feet away from my client or the residence, and again, have no contact with her. Mr. Baldwin and myself can communicate as necessary. Family home. Again, I thought this was going to be one that was stipulated to. We were somewhat surprised when Mr. Ubel in his declaration asked that home be sold. Again, my client is elderly. She doesn't have the credit rating to find a new place. She doesn't have the physical capacity to move. Under ideal circumstances, moving and relocating is difficult, especially when you're the age of my client and with the physical limitations she has. We did find it odd, my client details this for you in her reply declaration, that although he says he loves her, he wants to stay together, he wants to remain married, he does two things that stand out. Number one is he doesn't want to give her much money, if anything, for spousal support. And number two, he asks that she be removed from the home and essentially forced to relocate on $896 a month in Social Security. Seems like that's an individual who, and again, it dates back to some of these behaviors on the restraining order request. Somebody who wants his cake and essentially wants to eat it too. So again, I do ask that the status quo remains since these parties separated, which is my client remains in the family home. Oh, by the way, on a street that's named after my client, Ida Lane in Castle Rock. So we do ask for that and make no changes substantively as it pertains to that. Finally, we are making a request for legal fees. I think given the length of the marriage, given the fact that we've got one party who's enjoyed the benefits and separating of nearly 100% of the financial control and benefit in this case, that an award of attorney's fees and costs is appropriate. My client details for you her concern with this is the money has run out. My retainer is gone. My client does owe a specific amount to my office, and we've got a trial date right now that's not set well until well into the spring. Assuming that goes, that's still an extended duration that she's got to again try to piece together financial resources that she does or doesn't have, and that comes at a cost. My presence today certainly comes at a cost. What we're going to do in the future comes at a cost. We are asking for a contribution in fees in the amount of $3,500 to be paid within 60 days of entry of the temporary order. Again, we think that is beyond reasonable for kind of how we've arrived at this point. That's the basis of our motion. That is the relief that we are requesting. And finally, I don't want to forget this point because it is contained in my client's declaration. Mr. Ubel, as it pertains to the fees, has had counsel for the divorce throughout, counsel through the protection orders throughout, counsel through the criminal matter throughout. My client has not. She's had me in the divorce. She's represented herself in the protection order and throughout that process. And again, if we're comparing apples to apples, after 54 years of marriage, we do believe it is certainly consistent with the statute, put these parties in financial parity, which again is pertains to the attorney's fees and requests for costs as well.
Thank you. Mr. Baldwin, go ahead.
Yes, Your Honor. So significant issue here, maintenance, the amount, it doesn't appear either party did a financial declaration showing need, which is certainly an element of maintenance, even for a long-term marriage, notwithstanding the obvious difference in their incomes. My client's income stream comes from sources, a significant portion of which aren't divisible. It's not an inaccurate statement. The court can consider them inability to pay, but there are ultimately issues created when those sources are the basis for maintenance. In this case, the significant asset is the home. My client has maintained throughout the entirety of this case and every hearing and opportunity that he did not commit the acts alleged that brought about the protection order, notwithstanding court granting it. Your Honor is familiar with that, having heard it initially. They were renewed by Judge Warning for 1 year, I think in large part because of the criminal case that was pending. I'll address that here. We did file the verdict form. It was referenced in both declarations about the accusation, but not acknowledged that it resulted in a jury finding of not guilty. I know the burden of proof is different in a criminal case. The evidence as it pertains to the criminal case was filed in the protection order matter at the renewal hearing and addressed the circumstances. The text message to his daughter was asking for his daughter's phone number to contest her claims he'd had contact with her. The phone number for his brother in his phone had her number attached to it, and that's where the contact came from. That was the evidence presented to the prosecutor's office and addressed in the jury trial, and the jury came back with a verdict of not guilty. So their persistent claims that in and of itself justifies both the entry of an order or extending the order, maintaining the protection order, I don't believe is in reflection to reality as far as the protection order goes. So that's one. As to the financial, there is a pretty significant issue here that is the home. I don't think it's fully accurate to identify that it's a surprise. The main contention during the protracted discussions about a resolution has to do with how the assets of this couple after 54 years were able to be separated. The assets are the money coming in the form of maintenance, VA benefits, and Social Security to our client because he worked, and the home that is owned free and clear by the declaration of misuse. She lives there with no rent, no mortgage, nothing besides the cost of property taxes, which she's asking my client to continue to pay, and homeowners insurance. She appears to want to continue residing in the family home that is owned in full, free and clear, and also take near equalization of the monthly income stream to our client. That's what she wants now, and I think that's what she wants when the case is over. And
yeah, Judge, if I'm understanding the argument correctly, to one, the relevance of that, and two, anything that's pertaining to settlement negotiations, I don't think is properly before the court.
Yeah, and I'll disregard that, but go ahead, Mr. Baldwin.
Yes, Your Honor. As it relates to the temporary order, she's asking to continue residing in the home. Their proposal of a $900 reconciliation to my client between a true equalization and the requested $2,500 a month doesn't account for the cost that it would be to rent that residence. Nothing presented by either party addresses the property. I will say that there's reference to in the reply declaration by Ms. Ubel that she's lived in that home her entire life. We didn't have the ability to respond to that. That wasn't something that was addressed in their initial pleading. The home was built in 1970. They lived there their entire marriage. This wasn't a scenario. This is the home she grew up in. This is the home they shared together for the entirety of their marital life, and something that my client was dispossessed of just the same. We're asking the court to impose maintenance in an amount less than $2,500. We propose $1,500. We are asking the house be put up for sale so that the true value of that remaining asset can be identified. Because I think ultimately, at the time the case does go to trial, it is going to be essential to have that value and that money so that a fair and equitable dissolution of the parties can be made. My client opposes the entry of the protection order, does not believe it's necessary or appropriate. There is still the extended no contact order that was entered in Superior Court through next month, I do believe. And my client maintains he did not intentionally violate the order, went to trial and was found not guilty of having done so, and continues to deny the underlying basis for the order exists. He doesn't want to be separated or divorced. Ms. Ubel has brought this to court for temporary orders. I will also say his declaration, our client's declaration, indicates that he has, despite the fact that they've not been able to have contact, continued putting money into a joint account for her use and benefit from his income stream. That's not refuted or disputed by Ms. Ubel in her reply declaration. He has been providing money for her to be able to use to continue to live, survive. I disagree that it should be set back to September. Whatever the court enters should be effective October, and that maintenance should be in the amount of $1,500. And again, I reiterate that we're asking the house, as the only real tangible asset, be ordered to be put up for sale. I'm not saying even immediately. The court set a reasonable time frame to list it for sale. That's a significant asset that the parties will be able to use to equalize in the dissolution.
And do we know, for either one of you, do we know the approximate value of the home?
The current tax assessed value, Your Honor, is between $350,000 and $375,000.
Okay, and no mortgage on it at
Correct.
this time?
That's correct. The 2023 tax assessed value was $376. 2024 was $350. I don't know why it went down. A lot of other properties have gone up, so I don't have that information. I don't think my client does either because he's not been in the home for 2 years.
And then your client, Mr. Baldwin, does he pay rent where he is now? Did he purchase? Does he live with family?
He pays rent now. He was living basically in his car and functionally transient. He's living in an apartment. I believe his rent right now is about $1,000, maybe a little bit less. Utilities and other things. The only other thing I did put in, he's in my client's declaration, but I did address orally, was a boat that is on the property. My client believed that the parties had agreed he could have someone pick the boat up, and that turned out maybe not to be the case. So he's asking for possession and use of the boat. He is able to still go out fishing, and Miss Ubel has no use for it at this time. So he's asking that he be able to pick that boat up or have somebody go pick the boat up.
Okay. All right, Mr. Zandy.
I'm going to start with what I think is the easiest issue. It seems to be, again, somewhat broad, just in spite of this motion, which is the family home. You look at this, practically speaking, you're asking a lady who is elderly to vacate, and maybe I misspoke. The only home she's known over her adult life. So we're going back to 1970. She is where she's at. The fact that she's been here for 2 years post-separation, the fact that we have these issues, asking to, again, transplant her, tell her, okay, you need to uproot and go find a new place. If that's to happen, that needs to happen at the trial court level, not on a motion for temporary orders. So we would ask that you certainly deny that, because that is a case that would quite simply throw my client's life somewhat upside down at this point, which nobody wants to do, especially when we have a trial set for hopefully the early spring. Now, that's first and foremost. Second of all, if we look at, and again, Mr. Baldwin introduced some information. I have no idea about this vote. I know that we have discussed that over the past couple of months. I did not see that, or at least it didn't register that was one of the requests from Mr. Ubel. I think that's an issue that we can resolve between us. We attempted to do that in the past. I thought we had made some headway on that. Nonetheless, I don't think that's part of the motion, so that's the order should be reserved on that. Finally, and again, if we look at this suggestion that an individual who is making in excess of $7,000 per month between Social Security, a pension, and a VA benefit was forced out into his car to live homeless, then he's transient by choice, because most people without any debts, and there's very little debt here for Mr. Ubel, can certainly live off $7,700 per month that they're bringing in. So this explanation of, well, he's had fallen on tough financial times, because that's not borne out by any information before you. Now, that's certainly never been raised up until this point now, on the verge of us asking for some support and some attorney's fees. Although I would agree that to some extent, not entirely with counsel, that Social Security may not be divisible through a property distribution divorce. It can certainly, and most certainly should, be considered as an income stream for support purposes. That's money he has access to. It's money my client does not have access to. And after 54 years of marriage, again, the court is going to look to equalize these parties, not only from property and debt assets, but in addition to streams of income and on the support side. So again, if you quantify that $900 difference that I made in my opening remarks and apply that to his rent, again, these people are exactly equal in perfect parity with one another under our suggestion of the $2,500 per month. It also calculates, or at least considers to some extent, which is an imperfect science, this fair rental value of the Ida Lane home that my client currently resides in. So looking at it in that context, again, our suggestion and our proposal for maintenance is reasonable, certainly coincides with the statutory factors as well as the case law related to long-term marriages. And we do think it's reasonable given the circumstances, and ask for you to adopt the proposal set forth in our motion.
Okay. Just before I go too much further, I think we have some more folks on Zoom that may or may not be legit. So give me just a second to deal with that before we go further. I know Kurt Thompson is online.
It's the other side of.
And do we have Tina Thompson, or excuse me, Rihanna Thompson?
She's present in the court.
Thank you. Good morning, everyone. This is the minor guardianship docket. I am Commissioner Carly Bliss. We have a few matters on today. The first one I want to call is the guardianship of Isaac Ross. I see I have Ms. Powers. Are we expecting anyone else today?
No, Your Honor.
Okay. And being as this is a conflict for me, I see the orders don't expire till Friday.
Could we put this to the Thursday minor guardianship docket?
That was my thoughts as well. So let's go ahead and set this to Thursday, October 10th at 10 a.m.
Thank you.
And I believe we only have two other matters. Are either of those matters, is anyone requesting a continuance or a set over in those matters today?
Morning, Your Honor. In the matter of the guardianship for Angel, we would ask for a sit over on the basis that the respondent filed a counter petition, an objection to the petition, but I did not receive it until this morning.
Okay, let's go ahead and call that matter 24. Do I have anyone else present on that matter? I don't see Mr. Anagnostou, who I believe should be present. Should he not?
Yes, so. He's on his way. He's logging in now.
Okay, so let's go ahead and put a brief pause on that, and we'll recall that once we see him. 08. Who do I have present on that matter?
Mackenzie Pitts and Dinah Shane.
Okay.
And Brooke
You're the petitioners, is that correct?
Yes.
Okay, very good. And who else do I have?
Brooke Parrish, the mother of Journey.
Very good. And I believe we're before the court on two matters today, to approve the petition and for an order to show cause. Is that your understanding as well?
Yes.
Yes.
Okay. Let me just get into the file here. Have we got service on the father in this matter?
We have been having such a hard time trying to serve him because as far as we know, he doesn't have a place. We have tried, and the last person who tried to serve him said that,
Well, the sheriff's office.
well, yeah, the sheriff's office also tried, and then we had a person non-party to the action trying to serve him, and when she talked to someone, they said that they weren't living there and that he was couch surfing. So
Okay. Does he, I guess let me take a step back. Have those proof of non-service been filed with the court?
yeah, from the last hearing, that one is already filed.
Well, one was, do we have to file the?
Oh, I guess I do have a question on that. So the Cowles County Sheriff's Office, did they file paperwork or did we have to? I guess we should have asked that a while ago. I'm my bad on that. Because I was
They said they had their own paperwork for it, so I wasn't sure.
So typically when the sheriffs are serving on your behalf, they do file, and I do see that a proof of non-service was filed on September 26th.
Okay.
And it says that Mr. Malone was not found. So at this point, I don't see that father has received service. With no fault on you both, as it seems that there has been several attempts. But before me, I don't have proof that he's been served. And I need that to proceed.
Okay.
Have either of you filed a request with the court to allow for alternative service?
No, when we spoke to someone last week, they said that we have to do it in court with you.
To ask the judge.
Okay.
Is that something we can do?
Yes. No, you're totally fine. Typically, we require a motion because the file does need to be clear of the orders that I'm making on the bench.
Okay.
So I would ask that either of you file a motion requesting that I allow for alternative service.
Okay.
And that can typically be if you know that he has a Facebook account or something to that effect to prove that he is able to receive those documents.
Okay.
Do you, off the top of your head, do you know if he has any sort of social?
Yes,
I think he does.
I know that we could probably get that sent over.
Have someone do
Yeah.
that for us.
Very good. Okay. And I guess I want to turn to Mom. Mom, what is your position on the minor guardianship?
So basically, I just want my daughter back. I want the chance to be a mom. I feel like I've been hindered at any point of being a mom. I've been a sister this entire time. I'm ordered to call her sister. I'm not allowed to have her know that I'm her mother. And to me, it's putting her back. It's putting me back. Her sister, Destiny, knows they know they're sisters. And Destiny wants her sister back. She just needs to be home with her mom, her sister, her family. She's still young. I can still get to know her. All I want is to be a good mom to that little girl. And I am nothing, but I can do nothing but do that. I have a great life. I'm thriving. My daughter's thriving. She's doing great. She's in the 6th grade. I won her back from the state of Washington. I've been great for almost 7 years. I graduated drug court. All I want is for that little girl to be home with her mother. And I actually have tickets to come pick her up on Saturday.
And what has your, while this minor guardianship has been pending, have you been having any sort of visitation with her?
No, I haven't. I'm not supposed to have any of this. There's a restraining order that they asked of me.
Okay. I do see at least in that order, there is a stay away order. So I do see that.
Yeah.
The concern I have is A, we don't have service on one of the parents. B, at least from my review of the file, there's been an extended period of minimal contact, I'll say at best. And you can correct me if I'm wrong in my interpretation of what's been filed.
I have tried. but it's not,
Okay.
it doesn't go anywhere.
So what I would ask is that the petitioners, either of you, file that motion for alternative service so we can ensure that father does get served. I guess I'll turn to the petitioners as well. Do you have any objection to any sort of contact between mom and Journey?
No, we've actually never given Brooke a standstill of not being able to talk to Journey. We've never done that her entire life.
Until now.
Until now, when she said randomly, I'm going to come get my daughter. Yes, granted, she did give birth to her, but we've had her for 10 years. And
Brooke has been very inconsistent.
Every sense in the word, we have done the entire work to make her who she is today. And I'm not discrediting Brooke. She is her mother. I'm proud of her for getting clean, but this is not the way. She barely knows her.
It panicked Journey. Brooke had sent
a message. She sent I'm sorry.
She sent DCYF over here with false claims, and they came as a surprise visit. So they came in, they came to the house, they went through the house, they saw the kids, deemed it false. She's been back a time or two since then, and we've spoken with her. We had to ask her for advice because we weren't sure what to do, because on the 6th, DCYF came. On the 12th, we got a message from Brooke saying, I'm coming to get my daughter, have her ready. And I had to talk to Elise from DCYF and ask her what to do as far as this baby girl's concerned, because I'm trying to do the right thing and I don't want her tearing at me and crying and not knowing what's going on. So we had a family talk. I told her who Brooke was to her, and she wanted to talk to Brooke after that. This is all before this came down to where we had the paperwork filed, and Brooke would not answer any calls. She wouldn't call. She has been.
We had messaged her and let her know that Journey knows that Brooke is her mom.
I was told by the sheriff's office not to interact with any of them.
Ms. Parrish, I'll give you a moment to respond, but let me continue hearing from the petitioners.
So we messaged Brooke on 3 different phones, letting her know that Journey knows that Brooke is her mom and she wanted to have a conversation with her. That is the least that she could have done for her, is have a small conversation, and she wouldn't even answer the phone. She wouldn't answer the text, a call, nothing. So we felt like we were kind of forced to file this motion so that way we could push it back. Like, there's no way that, in my eyes, a woman who has not been in this child's life for 10 years can come take a baby
all the way to Texas
and just take her away like that.
Everything she knows is here.
My
her
mom
school,
has been raising
doctors.
her.
Folks, I'm going to ask that one of you speak at a time. I'm having a hard time tracking.
You go ahead, babe. Or mom. I'm sorry.
her everything's here. Her doctors, her school, her friends, her all the family that she does know. And she's doing very well as far as when she started. And, she was having all these problems, and I've had her in the Progress Center. We did the Youth and Family Link. We've have had her in K-12 and in Butler Acres, and she is doing amazing. She's actually graduated out of one of her IEP programs that she needs because she's doing better. And I do not want to derail that. We've done a lot of work to get her to this point. A lot of things that Brooke does not know about that she has went through.
And I would also like to point out, since we let Journey know who her mom is, she's had an excessive amount of bedwetting.
And I've got her an appointment at the counseling office here in town. And as soon as I can get it,
with?
30th. Pardon?
Who is that appointment with?
Columbia Wellness.
And when is that appointment scheduled?
It's on the 30th, and I just want to make sure she's okay, That's
the 30th of October.
Find out. What's that?
The 30th of October?
Yes.
Okay. Ms. Parrish, do you have anything else?
Well, I mean, I guess, so I'm not going to be able to come get her this weekend, correct?
No, because we have several procedural issues. One, we don't have father being served at this point. There is an immediate order in place placing Journey with, excuse me, the petitioners. There's a lot of uncertainty that I'm still unsure of. I'm inclined today to appoint a guardian ad litem on behalf of Journey. I do want to address visitation, but at this point, by statute, I have to be able to find that it's in Journey's best interest, in addition to if there's a parent willing or able to care for the child. I have no doubt that you, Ms. Parrish, are willing to care for her. I have significant red flags and questions as to if that's in Journey's best interest. And that's why I want a guardian, that's why I want a guardian ad litem to give me more information as to what is in Journey's best interest.
Okay, and I have something to say. Is that okay?
That's absolutely, go ahead.
All right. So I've been paying for my sister. I pay TANF, non-needy TANF to my sister. I don't get to see her, to get to talk to her, and I don't know that there is sister support. I just want my daughter home, and it seems that every string that you guys can pull, Dinah, is being pulled and just prolonging it and prolonging it and prolonging it. It seems as though even the court thinks that Journey it shouldn't be with me. And if the court thinks that you guys are the best choice for her, I love that little girl. I love that little girl.
Ms. Parrish, I'll ask that you direct your commentary towards me and not the petitioners. This isn't a time to go back and forth.
Well, I love the little girl, and if they think that that's the best place for her, then let's do that. Let's do that. I can sign my rights over, and you guys can do that, because I can't fight anymore. Mentally, ma'am, I can't do it anymore. I'd go to weekly therapy because I have seizures, and they're trauma seizures, and I seize every single day. I'm been going to therapy, and this is one of the hurdles I've been trying to get over, and it clearly isn't going to be something that's good for my daughter. Whether she's my daughter or not, if it's not good for her, then I don't want it. I want what's best for her. And if my mom and my sister think that's what's best for her, and they've had her this long, they're right, they have. But I wasn't going to give up without trying. Do you know what I mean? Because I do love that little girl, Your Honor. And if they want her, bring me a piece of paper, and I will sign my rights over, because I can't do this anymore with you guys. I love you guys to death. I love that little girl to death, Your Honor. But if it's not in her best interest, I have to let it go. I can't keep doing this. Do you know what I mean?
I hear you. I hear you. Ms. Parrish, what I want to ask you is, have you spoken with an attorney about this issue?
No, because I can't keep dragging this. It's mentally not fair for her, and it's mentally not fair for me. I can't. I felt like if we didn't get this resolved today, if I couldn't come get her and I couldn't establish a relationship with her, then I just would rather her be with her mother, Dinah. And that's really how I feel. I love her to death, but if she is in better care there, and that's really how I feel is being pushed, that's okay. They know her the best. I don't know her. That is the truth. And if she wants to have full custody of her, I will sign my rights over, but I'm not going to pay sister support anymore. And I'm not going to keep trying for something I can't have, because mentally it's draining. And I'm doing very good, and I'm thriving my life. And I just wanted to share that with her. And that's okay that I can't. I'm okay. I'm accepting. I'm okay. I just want Dinah, if you could, or Your Honor, if you could have Dinah send me to sign over my rights, I will do that gladly. Because if that's what's the best interest for the child, I will do that.
Okay. Thank you. Ms. Shane or Ms. Pitts, is the child or is your family receiving TANF benefits?
Non-needy TANF for Journey, yes.
Okay.
I believe that Brooke,
Hold on, Ms. Pitts.
I believe that Brooke did provide the paperwork showing that she was paying it or is paying it.
Okay.
So if you need that, it is there somewhere.
Okay. Ms. Looney, I see you're present today. Does the state, from your perspective, have an interest in this matter?
Your Honor, the state would become involved once both parents were served in this matter.
Okay.
So I'm just observing today, but yes, that is accurate that the child is receiving TANF benefits.
Very good. Thank you for that clarification. So at this point, I'm going to, I want to speak to the parties a little bit more. So previously, I had contemplated extending the minor guardianship order until we could get father served and appointing a guardian ad litem on behalf of Journey. Now hearing Ms. Parrish's position, I'm going to turn to the petitioners. how would you like me to proceed at this point?
I'm gonna be honest. I think for Journey, I would like to just get it over with. Let's just get the paperwork done. If that's what Brooke wants, let's do it, because we have never wanted to keep Brooke out of this at all. We wanted to keep this out of court. That's why we were messaging her. And you can see in the screenshots we provided that we have tried to get a hold of her on multiple occasions. And some of them I'd like to say is my screenshot. I was not nice in the first message, and I apologize for that, Brooke. I do love you.
I love you too.
And I really, really believe that this should be on Journey's terms. Now that she knows who you are, I think that we should just rip the Band-Aid off, have the paperwork filed completely, and then let's leave it up to Journey. If she wants to get a hold of you and have that relationship, let's let her establish it with you.
I agree. And whatever's best for her. I just want the court to know, I love that little girl. And I want you guys to know, Your Honor, can I just address them? I
Yes.
love you guys too, and I love that little girl. But what you guys said to me about me on there is not true. I have not used since October 1st, 2018. I was nowhere near you guys in 2018. That is not right. I take
I have videos
pride
of
in
you,
my
sweetheart.
I take pride, Your Honor, in my accomplishments. I have worked so fucking hard. Excuse my language. I worked so freaking hard to get where I am at. And all I want is that little girl to have her mom, because I don't have my mom. I don't have one. So that's all I wanted. And if it means to say my rights, I'll do it.
So Ms. Parrish, at this point, I'm going to extend the immediate order on the emergency minor guardianship. Ms. Pitts and Ms. Shane, I still want you both to file the motion for alternative service. We can't enter final orders if father hasn't been served.
Okay.
So we need to get him served, or at least notify him of this proceeding. If he chooses to respond, that's on him. But you have to do your jobs as petitioners to make sure that everyone who is entitled to service receives service. So I want you to file that. I am going to set a review hearing in 60 days. Let's set a date for December 3rd is close to 60 days. We'll do December 3rd at 10 a.m. Presumably by then, he has been served. Final orders may or may not have been prepared and signed off on by Ms. Parrish. Given that that's the route that you folks are hoping to go, I'm not going to appoint a guardian ad litem today. I do encourage visits, and we can discuss putting that into an order if you both think that that's, or the three of you believe that that's appropriate.
Okay. And then you said I'm sorry, you said that we need to get Derek served. And
Yes.
I believe that we can do that, honestly.
We have to file for
and then file for the motion. And then you said one more thing, and I really can't remember, and I'm very sorry for that.
That's okay. We're having a review hearing on December 3rd. By that point, I'm assuming he will be served and that final orders will be forthcoming. If not, at that point, I will have a note in the system to have a guardian ad litem appointed to ensure that this matter does seek finality. Journey does deserve that. All of your families deserve that, frankly.
In final order, is that like a submission of paperwork? Is that what you're saying, final order?
So in reviewing the file, and thank you for bringing that to my attention, you do have a full guardianship filed. So if you go to either the clerk's office or the court forms website, you can look up final minor guardianship order or order on minor guardianship. That's what I'm speaking of.
Okay, I'm so glad you clarified. Thank you.
Oh, give me just one moment. The clerk's speaking with me. Sure. So I do see that you have already filed that, or at least prepared it. Obviously, we have some issues regarding service that need to be perfected. Extending. Mm-hmm. Yep, I will. Okay. So I do see that you have already prepared it. What I will task you with doing is if the three of you want to discuss entering this by agreement, which is what I understand is coming of today's hearing. It's likely that there will need to be some revisions to that proposal that you've submitted already. But it looks like you already have that final order. You found it already. So it's just a matter of whether or not you revise it and reach an agreement and get signatures from at least Ms. Parrish after Mr. Malone has been served. Well, it looks like Ms. Pitts may be frozen. Ms. Pitts, can you hear me?
Oh, no.
Oh, there we go.
Are we
back.
good?
Yes, you're back.
Okay. I don't know what happened. It said the network was unstable all the.
And it looks like we may be having that happen again. Ms. Pitts, what I'll ask is that you turn off your camera. Sometimes turning off your camera saves some bandwidth.
Sorry about that.
That's okay.
What was your
And we're losing you again.
Okay, perfect.
Are we there?
Okay,
there
all
we
right.
go. Can you hear me?
Yes.
Very good. Okay. So what I was saying, and I don't know at what point you dropped off, but I do see that you have a final order and findings on minor guardianship that you have prepared and presented to the court. Given the discussions that occurred today, I'm assuming there's going to be some revisions that need to be made. But I'll leave that to you folks. So you've already found the order, so that's the first battle. So I would task you both with revising, chatting with Ms. Parrish. If you folks can come to an agreement and enter that with all of your signatures, we would be happy to sign it. But at this point, obviously we have the service issue and whether or not you folks are able to reach an agreement. That is what I'm going to assume is going to occur in the next 60 days.
Yep.
Okay.
Your Honor, just have them send me the paperwork or do whatever and I'll sign it.
Okay. Anything else on this matter today? I will be signing, the order extending immediate restraining order. I'll do that off docket today and file that ex parte.
Thank you.
Any other questions from you folks today?
Yes. If we have a stay away order, how can we come to an agreement? Can I call her after this hearing? Can I call you, Brooke? Is that okay?
So let me answer that first, to the extent I can. So I can't give legal advice. I can't interpret an order. But I would task you to do is look at the verbiage in that order.
Okay.
It does say stay away. It restricts Ms. Parrish from coming to your home. See if it says anything as to communications.
Okay.
I'll leave it at that.
I just didn't want to, be a part of something that we weren't supposed to be doing. And then another question, if we do come to an agreement and paperwork needs to be signed, can we certify mail it?
To Ms. Parrish?
Yes. Okay, I just wasn't sure because we've been doing the process server and it's just starting to become an expense.
Absolutely. And I would encourage folks, I know it's really difficult to practice law when you're not an attorney, but there are a lot of resources out there that discuss what type of service is required for what type of document. So I'll refer you to that to determine whether or not personal service is required anymore and when it is. That may help you moving forward.
Okay, thank you. I appreciate it very, very much.
Absolutely. Ms. Parrish, anything else from you?
Nope. Thank you, Your Honor.
Okay. If nothing else, then that is it for this matter, and you are all free to go.
Thank you. Thank you.
Thank you. I believe Mr. Reisenberg had a request when we first called this matter.
Thank you, Your Honor. Yes, asking for a 2-week set over on the basis I just received the respondent mother's objection to the petition and declaration this morning.
Mr. Anagnosti, your position?
I guess I don't have a big opposition to a set over. My question would be, are we going to appoint a guardian ad litem? My client has requested a guardian ad litem be appointed. I don't know if there's going to be an objection to that. And wondering if we can at least get that accomplished.
And that was a note that I had made in reviewing the file, is that a guardian ad litem had not been appointed. I would, and I'll turn to Mr. Reisenberg in a moment. I personally believe that a guardian ad litem should be appointed, but I'll defer to Mr. Reisenberg. What is your client's position on a guardian ad litem?
No objection.
Okay. And do we have, sorry, let me go back to, is there anyone else present in that, for that matter today?
Amy Turnbull, Your Honor.
Thank you, Ms. Turnbull.
And April Nicholas, I'm the petitioner.
Okay. Good morning, Ms. Nicholas. Thank you.
And my client is here.
And that's Miss
Nicholas.
There we go. Okay, here we go. Sorry, it helps if I had the right screen pulled up. Okay, so hearing no objection to a guardian ad litem be appointed, I am inclined to have Ms. Farr be appointed. She is the next on our list. And so I will, counsel, can you send me a order appointing?
I can do that, Your Honor. Sure. Circulate it to Mr. Reisenberg.
Very good. And with that, counsel, are you requesting a 1 week set over or 2 weeks?
I was requesting 2.
Mr. Anagnosti, do you have any objection to October 22?
I do not.
Okay. Let's go ahead and you folks circulate that order appointing Ms. Farr, and we'll set the remaining matters over to October 22nd at 10 a.m.
Okay.
Games.
I'm sorry, what?
I can still go to our games.
Yes. My client is just asking about the soccer games. She's been going to the soccer games, and as far as we know, there's no restriction on her at least being at the soccer games.
Your Honor, I'll just offer, the petition did not include a request for a restraining order or protection order or anything like that. Judge Basher in our last hearing did say that that would be okay.
Okay. And I was just pulling up that order. I don't see that any restraining order or any orders limiting the presence of mom at soccer games. So I'm going to allow that to continue.
And I've been sending her the dates of all the games too, and the locations.
Very good.
Thank you.
Thank you, Ms. Nicholas. Anything else on this matter today?
Your Honor, with the appointment of Ms. Farr, are my services as a court visitor needed anymore? May I be released?
I would think that that is appropriate. Any objection from counsel?
No objection.
No objection.
Okay. Ms. Turnbull, you are relieved of your duties today.
Thank you very much.
Thank you. Anything else?
Nothing.
I was going to see if I could ask a quick question. I kind of heard you say in the previous one that, because I've been trying to serve dad. Like I contacted the Oregon State Police because he's a registered sex offender. The address he has is completely fake. I talked to the assessors. There's no such parcel for that address. I've been reaching out to the Oregon State Police to see if I could locate an address because of him falsifying his address with them. I did find out he does have a Facebook page. So I'm just trying to, and you said something about maybe putting in a motion for serving him alternatively. Sorry, I'm not a legal, I don't have my own lawyer, everybody else has one. And I'm just trying to figure out what I can do to serve dad in a way that I haven't tried. Because I mean, higher paying guy and all that, it's kind of been getting, just to get mom served was a lot of work, and I'm trying to get dad and I don't know what else I can do.
Have you filed, excuse me, proofs of service or proofs of non-service for dad?
No, because I didn't. I've just been trying to reach out to try to find nobody will serve him because there's no such address.
Okay.
And so I don't know how to, I have emails that I've sent to I have phone calls that I made, so I don't really have proof of that, but I have emails I've sent, even in July, I've sent to Oregon State Police stating, this is what's going on. I don't know what else I can do at the moment because there's no address.
Okay. And do you have correspondence received from any of those entities saying that they won't serve him, things of that nature?
They told me to call him. I called them, so I don't have an actual log. I do have emails showing that I've reached out to them. And Oregon State Police have not responded to me. So I did, when I called them, they told me to contact their higher ups. I used the email they gave me. I just have not received any responses.
So you heard me speaking in the last case as to if a motion were filed, someone on the bench could review that and determine whether or not you have made sufficient attempts at service to warrant an alternative means of service. I can give you legal advice. I can't tell you what you can, should, or, anything of that nature. But if you are having difficulties finding dad, obviously we do need to have service on him in order to proceed. So I would encourage you to look into that.
Okay, thank you.
Yes. Anything else from any other party today? Hearing nothing, I will conclude this matter and we will set it over to October 22nd at 10 a.m.
Thank
Your Honor.
Thank you all. And I believe that is it.